So at this point, you should all have your free speech essay approach out. And how you would begin your essay is just like you began it for equal protection. You're going to start with state action, whether it's a local, state, or federal actor, and then you're going to get into standing. Remember to always establish both of these issues, state action and standing. State action or standing missed could be up to 20 or 30 points off your essay. So you want to make sure that you're constantly using it as a check mark in your head. State action, standing. Then you're going to define free speech. So you'll have a heading, free speech. The First Amendment provides that Congress shall make no law abridging free speech. That's it. That's your rule. Obviously, it's within the First Amendment. Don't forget to give the amendment. Now, we're going to use our hurdle approach. Just like for evidence and just like for contracts, we walk the speech through a series of hurdles in order to determine whether or not the law that's potentially abridging one's right to speech is constitutional or not. So the first thing that we want to do is determine whether the speech is content neutral or content based. And you only go into the ones that apply. You only discuss the hurdles that apply. So your essay answer should have state action, standing, the definition of First Amendment freedom of speech, and then merely listing any potential hurdles to that speech that applies to either allow the speech or not. First, is the regulation content-based or content-neutral? Well, if it's content-based, as you see on your approach, there are two ways to find a content-based regulation. One, subject matter restrictions, laws that confine or stop the topic of the speech. Or two, viewpoint restrictions, laws that go to the ideology behind the speech. Courts will apply strict scrutiny here. So we have viewpoint or subject matter. Typically, both viewpoint and subject matter come together. So if the regulation is restricting the viewpoint, then it's also typically restricting the subject matter. And in order for that law to be upheld, it must meet strict scrutiny. Remember, this is the government's burden in a content-based regulation. A good rule of thumb is to headnote subject matter regulation, as I have on your approach, then go into strict scrutiny, then headnote viewpoint and go into strict scrutiny. Next, unprotected speech. Now remember that the speech may not fall under every single one of these hurdles or categories. So only discuss the ones that apply. But if they do, you give the intro. If it falls under an unprotected speech, your introduction will look like this, or should look like this. The government can completely prohibit the incitement of illegal activity, obscene language, fighting words, and defamation. Those are 4 forms of unprotected speech. So you only go, and I would give the intro as to all 4 types, and then just headnote the ones that apply. Or you could say here, the speech falls under category 1 and 2. Incitement of illegal activity, so it would deserve its own heading. Speech that involves the incitement of illegal activity will be unconstitutional where 1, there is a substantial likelihood of illegal activity, and 2, there is an intent to cause an imminent illegal act. So incitement of illegal activity, the key buzzword is imminent. Not sometime in the future, but an imminent illegal act. Next, obscene, obscenity. For material to be obscene, you have to make sure you know this 3-part test. This comes up a lot on the MBEs as well, and it has been tested a lot within free speech. It must appeal to the prurient interest. The material must be patently offensive in relation to the material. And 3, there can be no scientific, artistic, political, or literary redeeming value. And what I want you to do is separately headnote all 3 parts of the test. So prurient interest, patently offensive, and redeeming value, and go into all 3 to see all of them must be met. Next, fighting words. Fighting words must be directed at another and likely to provoke a violent response. Directed at another, provocation. Those are your two elements. Defamation. Defamation within unprotected speech, First Amendment, is the same analysis under torts. So this is a potential torts constitutional law crossover. Your defamation approach here would be the exact same approach as in torts. Obviously, constitutional defamation would likely apply, typically where it's a matter of public concern. Commercial speech, false or deceptive ads, this is in regards to advertising, are unconstitutional. And just head note commercial speech and go into the rule there. It's a very straightforward rule. Symbolic speech, this has to do with like crosses or Stars of David, or even a Christmas tree. There's been a lot of controversy around these types of symbols being on public property, or government-owned property, right? Because we need government action, state action, within being in a courthouse, or even like outside of a public park. There's been a lot of case law on this. So it's highly, highly tested. Make sure you know the elements necessary for symbolic speech. Symbolic speech is one which conveys a specific message. 2, those seeing the message understand a message is being conveyed. The government can regulate symbolic speech when there is an important interest unrelated to the suppression of the message and the impact on communication is no greater than necessary to achieve a government purpose. That's your level of scrutiny. Specific message, understand it's a message, important interest, no greater than necessary. Okay, those are your content-based regulations. What about content neutral? Content neutral regulations are based on time, place, and manner. These are your time, place, and manner restrictions. So the time that you are allowed to maybe strike at a park, or the place or the manner in which you are. You must have a significant government interest, narrowly tailored alternative channels of communication. Those are your 3-part test. What are your other ways to challenge speech? So all we're doing within this approach, and that's why it's not necessary for me to just write this all out on the board, we're just taking the speech through a series of hurdles to see which ones apply. You will get major points off if you're not able to issue spot and identify the necessary challenge to that speech. So make sure that you really know the rules here. Other ways you can challenge speech: vagueness. A law that is unduly vague is unconstitutional. A reasonable person would have to guess at its meaning. Also, overbroad. Vagueness and overbroad tend to come together. Okay, so a law that regulates substantially more speech than the government allows is overbroad and unconstitutional. You also can challenge speech in regards to where the place that the speech is taking place in, so the forum for the speech. A public forum is a place traditionally allowed for speech. If the regulation is content-based, apply strict scrutiny here. If it's content neutral, apply intermediate scrutiny. A limited public forum. Government places that the government can close but chooses to leave open. Scrutiny applied is the same as in public forums. A non-public forum. A government place that they are allowed to close to speech. This is allowed because there is no First Amendment right to use privately owned property for speech. That has been tested as well. Next, prior restraint. It may be a prior restraint, a judicial order which stops speech before it occurs. The court order must meet strict scrutiny. This typically comes up in the case of licenses or permits, that you must obtain a license or a permit before you actually speak in a public place. In order for a court to be constitutionally allowed to order a license or a permit before certain speech occurs, the court must show, 1, the restraint is necessary to prevent societal harm, and 2, there must be procedural safeguards. And procedural safeguards, I want you to make sure you memorize these 2 words. There can be no unfettered discretion. Those are the words that the graders are looking for. Unfettered discretion in the issuance or denial of a license for speech. So those are your challenges. Those are the ways that you challenge freedom of speech and whether or not the regulation is constitutional. Obviously, you need to know all the rules in regards to these hurdles and their levels of scrutiny. We've concluded constitutional law, but I want to just say one very key important factor when you're writing. You want to make sure that you're not getting emotionally involved in your writing for constitutional law. Whatever your personally held views are on abortion, on gay marriage, on really anything that could come up, even freedom of religion, whatever we all have them, but I see a lot of times emotionally charged answers. You cannot bring your emotions into your answer writing for con law. You want to leave that aside and just go by the rules and the facts that you're given. All right, thank you so much. That concludes our constitutional law overview, and focus in on where they test and how to write for these areas. If you have any questions, like always, please let me know. Thanks and have a great day.